Thank you.
I call Jan Logie.
Mr. Speaker, and I've got to say this is it's been a unique process in my experience in Parliament, where of dealing with a bill that was just provisions in the statute's amendment process initially, that when hearing submissions in the select committee process actually threw up the fact that there was significant concern and disagreement around these provisions, which we on this side of the House have managed to, I guess, hold off to be able to get the best parts of what was in there into this bill, and saved the debate for another day where the community can participate in it on the contentious issues. And I do want to just frame this. So this is the Charities Amendment Bill that we're talking about. And we're told that this is, you know, small and minor and technical, and what's in this bill we agree is and we can support. So there are things like ensuring that somebody who's been convicted of tax evasion can't become an officer of a registered charity, and that does seem pretty sensible. And it provides that an application for registration as a charity can be treated as withdrawn if that organisation hasn't responded to correspondence in 18 months. And again, that seems good to clarify that. But it initially, they intended to put in another provision in there that we were told was correcting a drafting error. And I've got to say, this is something that I've heard a few times on different pieces of legislation going through this House that were often quite contentious points, and where no evidence was provided of to back up that analysis of the original intent. And in this situation, we had the department and the minister saying, this is inconsequential, it's really just tidying, don't worry. And then we had the community and voluntary sector peak organisation, Huie, and their lawyer, Sue Barker, who's generally acknowledged as the person in the country with the most expertise in this area of law, both saying that this change or correction of a drafting error would take away rights to appeal a decision. So, very, very different views. And we considered that that was not appropriate to pass through as if those different views didn't exist. So we are pleased that that didn't happen, and that we have this legislation without that point in it that we can support. But I would back up the Honourable Ruth Dyson's point that we certainly wouldn't be supporting this if it was put back in the committee stages, because it is getting beyond the detail of what that provision is and whether or not it is taking away of appeal rights. It's really, really important to us in the Greens about negotiating roles in our society. And I've spent most of my working life working in the charity sector. And we used to talk about the charity sector as the third sector. So there was government, there was business, which also included unions, and there was tangata whenua, community and voluntary sector, roughly the charity sector. And that wasn't a hierarchy. That was kind of almost like a Venn diagram, but not much overlapping, around working together to make this society work with different pieces of knowledge and understanding of what was going on. And there used to be a respect for our experience in the community. And government used to listen to us. Obviously, we always wanted them to listen more and do more things, but there used to be a time where we could speak out and say what we thought, and sometimes they'd agree, sometimes they wouldn't, but there was respect. Well, through this and what was shown in the select committee process and what I am hearing pretty much every day out in the community is that that culture does not exist under this government, that there is not respect for our community sector, our charity sector, shown by this government, that we do have agencies who are not able to speak up, because when they do speak up, advocating for the people that they're working for, then a few days later or maybe a few hours later, they might get a phone call from their funders at the ministry saying, "You do know you're not indispensable." That is not rubbish. Minister, you need to get out more. You need to listen more, Minister. You need to read the reports that tells how many agencies are on the point of collapse because of a lack of funding, because of the short-term funding contracts that you keep on imposing on them so that they are too scared to challenge you. And there would be not one person on this side of the House that hasn't had that conversation on a regular basis with people working, protecting the most vulnerable people in our society who are too scared to contribute to the public debate because of the actions of this government. And this bill is part of that disrespect, where the government goes, "Oh, we can sneak this through," and don't even tell the agencies that they're looking at making these changes. Not even the peak agencies that they used to have regular meetings with and a relationship of respect. They don't even tell them. And so then when it comes through in this process and there's absolutely fundamentally different views on what this provision would mean, it takes the opposition parties, the Labour and the Green parties, to say, well, actually, if there's this level of agreement, this should not go through. The government members of the Select Committee would, and backed up, I can only assume, by the Minister who brought it to the House, would have let it go through thinking they were right. Because that, and there we hear it again, they were right. Because that sums up the arrogance and the bullying power of this government. They will ram things over, so certain in their own knowledge, so certain in their own rightness, regardless of any other feedback that they might be getting. So we are proud that this bill now no longer includes that provision.